Welcome to the Estate Planning Made Simple podcast by LSPN, one of the nation's largest and best estate planning networks. The information provided on this podcast does not constitute legal advice. All information, content, and materials available on this podcast are for general information purposes only.
All right. Well, welcome to our weekly podcast meeting here. We're talking about why estate planning matters for your business. And so, today we're really focusing on business owners. And if you own a business, some of the things that you should be considering as part of your overall estate plan. Business owners are notorious, unfortunately, for failing to plan, right? When you start in business, the first thing that you're thinking about is making sure that your business can get off the ground, making sure that you can start, offering services or products, that you're taking care of your clients or your customers. And your focus is really on just making sure that you don't fail in business, right? 80% of businesses fail in their first year. And then, out of the ones that survive the first year, there's a big drop off of the ones that, fail in the second year. And so, one of the things that business owners a lot of times forget about is how are they structuring their business in order to maximize tax savings, asset protection, make sure that they're operating properly, and a lot of other things like that. A lot of times business owners don't think about that when they start out. The other thing is that a lot of business owners, once they're operating, they realize, okay, well, I probably should have thought about these things before. And how am I going to retain employees? How am I going to, make sure that operations continue to expand and grow? And, what are some of the things that I need to consider, especially if you have a business partner? But along the way, eventually, in the timeline of whatever business that you're in, eventually there's going to be also the need for an exit. And that exit may come in the form of retirement. It may come in the form of selling the business. It may come in the form of passing away and leaving the business to somebody else to run, part of an inheritance or otherwise. Or it may come in the form of an unexpected emergency, incapacity, disability, anything like that. And so one of the things we're going to talk about today is how to address your estate planning and business succession planning right from the beginning when you first start your business. And so what we basically talk about is what we call the 5 Ds of business succession planning. And so these 5 Ds are what happens in the case of divorce, what happens in the case of disability, what happens in the case of, incapacity. We say dementia because it starts with a D that way. What happens in the case of a dissolution of the business? So the business partners go their separate way and we want to, dissolve the business. What happens in that case? And then finally, what happens if one of the business owners happens to pass away? They die, right? And so, the idea of the 5 Ds is these are the things that in your operating agreement, if you have an LLC, or in your bylaws, if you have a corporation, or in your partnership agreement, if you have a partnership, these are things that should be addressed. And if they're not addressed there, then you probably want to have maybe a standalone document like a buy-sell agreement or something similar that will address your business succession planning needs. Part of your business succession plan should hit on these 5 areas. And we're going into more depth, but let me share a story with you guys. We had a client of ours, this was down in Florida. He had a successful business. It was doing all right for many years. And then, basically he reached that hockey stick moment that most, entrepreneurs, business owners look for. And it just exploded. So it went from maybe $1 million business to somewhere close to a $14 million business in the matter of like 2.5 years. And so he was getting to the point where he was, planning an exit. He was going to sell his business or he was going to retire from it. And he had finally made it. And he had gone through a very difficult divorce. His ex-wife was a little, abusive with the kids and stuff like that. And so he had wrestled the custody of the kids from her over like a 3-year divorce, right? So this has taken a long time, lots of stress. He finally got through the divorce, finally got the divorce order in place and everything else. And he was finally finished with all of that stress that he was dealing with. And then from out of nowhere, he ended up getting a stroke, passed away suddenly. And unfortunately, right, and the family was left picking up the pieces. And even though he had intended to do his estate plan, do a trust, put some documents in place, he had never gotten around to it, right? And so because when he passed away, he didn't have any documents to actually address his estate and the transition properly, guess who was on all of his beneficiary designations with his savings and with his accounts? The ex-wife. Guess who was the only person that was basically nominated, or rather in the absence of a nomination, right, to be the guardian for the children. So he has minor children. He had just gotten custody for them. He would have preferred to leave that custody to his parents, but of course he didn't put anything in writing. And we talked about that last week. And because he didn't have anything like that, then his ex-wife was the one that's going to have all the control of managing the assets for the children. So now the business that he had worked so hard to build, that had finally gotten to this hockey stick moment, his share of the business was going to be in control of his ex-wife. His business partners are horrified because that's the last thing that they wanted, was to be in business with her, especially after this 3-year divorce, right? That's the last thing that they would have hoped for. And in order to get her out, because they don't have documents in place, they're going to have to go back to court and have a judge, give them an order, basically declaring that they can buy her out, or that that they can push her out somehow. So that's a nightmare, right? When you don't have a proper business succession plan, or you don't have a proper estate plan in place, those are the types of things that happen. And we've seen it happen in multiple instances. So again, the 5 Ds that we need to plan around are what happens in the case of death. In this situation, he didn't have a plan. He didn't have a will, a trust, a proper estate plan, or a business succession plan on what should have happened. But depending on what kind of business you're in, we can address that need for planning around death through your own personal estate planning and through insurance. If you have life insurance, for example, and you have a key person in your business, that person may be able to continue managing the business, running the business. Maybe they even take over the business. And you don't want your family to miss out on the value of what the business would have generated otherwise. So you use life insurance that the business funds in order to replace that value through a buy-sell agreement, right? That's one example. Some businesses can't continue operating without you. If you pass away, it would require a doctor or an attorney, or some sort of licensed professional that might be not too easy to find. And so to replace that value, we can use life insurance, right? And there are other scenarios where life insurance becomes a very valuable part of your overall business succession plan. The second D is disability. What happens if one of the business owners becomes disabled? And in a similar sort of, situation, we also want to address that concern. And a lot of times we can address that through insurance as well. So we had another situation where there were 4 chiropractors. They were all partners, business partners. They had been operating their chiropractic business for, I think it was about 8 years at that point. And by the time I met with them, it was about 10 years. And what happened was that one of the business partners was in a bike accident. I think he got hit by a car or something like that. Anyway, he got injured to the point where he was unable to continue servicing clients. And so even though he's a licensed chiropractor and, was helping to build this business up for a long time, he had partial, paralysis, and he wasn't able to actually service clients anymore. And of course, the business partners that he's in business with were understanding. They want to make sure he's taken care of. But now fast forward 2-3 years later, and it's getting kind of frustrating, right? Because the business is growing, revenues are up, but it's also kind of bursting at the seams. They need more people servicing clients. And here's this guy who is collecting a paycheck, collecting a dividend check from the business, but he's not contributing, right? He's not servicing clients. And they box themselves kind of in a corner, because now he's used to getting this, these dividends and not contributing to the business, and he feels entitled, right? So now they say, okay, well, how do we fix this? And we had to negotiate terms for them to buy out his interest, and so that he could, feel happy with the exit, and so that they could move on and continue growing their business. It's a lot harder to do after the fact if you didn't have something in writing beforehand. And so again, a buy-sell agreement or business operating agreements can have these provisions that will specify ahead of time, If you get to the point where a contributing partner in the business can no longer contribute because of a disability, how's that going to be addressed? One of the things we talked about was, what if this happened to one of the other partners in the future? And they said, oh, we don't want to go through this ever again. It puts such a strain on the business to have one of us not be able to service clients. And we didn't have enough cash flow to be able to just bring in another doctor, another chiropractor, to be able to service those clients either. So you can address that through insurance, disability insurance, right? And the disability coverage can either replace the value of a lost partner to the business, or it can replace the income to that partner so that it's not a drain on the business. And then we can specify in the documents, how that's going to be reflected in terms of a buyout or in terms of an exit. The third D is incapacity. And in the case of, dementia or Alzheimer's or, anything else that could cause an incapacity, and of course we say dementia because it starts with the D, but it's very similar to the disability conversation, right? If you get to the point where you can't manage things with the business, that can cause problems. I have a friend of mine that I had done some work with in the past, and I got a call from his wife because he had been accused of a crime. He ended up having to go to jail for a short period of time, and while he was in jail, the family didn't have access to anything. They didn't have access to the business bank accounts. They couldn't collect on behalf of him with his clients. He had like $300,000 sitting in the business, but the family couldn't get to it, and so because of that, they were struggling. They couldn't pay their mortgage. They couldn't pay their monthly expenses. They, had all kinds of stuff going on, and they weren't able to access the value of the capital that he had built up for them. They needed a financial power of attorney to make sure that they could have access to those things. Well, if you want to see a business die, put it through a probate process, put it through a conservatorship process where somebody has to go to court in order to get the permission to access bank accounts or to work with clients or to work with, vendors. It becomes ridiculous, right? And so it's important to have these things in place ahead of time so that somebody's empowered to make those decisions if there is incapacity on the part of one of the owners. And again, incapacity can also be addressed with insurance. In fact, with our own, my own business succession planning for my business, I actually have one policy that doubles or triples, I guess, as a life insurance, a disability insurance, and an incapacity coverage, sort of insurance for long-term care, right? And so you can address it sometimes with just one solution, but it has to be tied into your legal paperwork so that everything can flow smoothly. And then the fourth one that we talked about is divorce. So I gave you an example of a situation where a business owner goes through a divorce and the nightmare that it can create for the business partners. But in the case of a divorce, the most common thing is that whatever assets are owned as marital assets, they're going to be divided. And that means that a portion of your equity in the business may end up with your ex. I have a client of mine who owns like 5 or 6 different Denny's. And we sat down with this guy and he was saying, well, I want to sell all of my Denny's restaurants, right? And they said, well, why? They're doing great. They're actually some of the top producing Denny's in the state. And so he says, well, I enjoy it. I love it. I, wouldn't sell them normally, but I went through a difficult divorce about 12 years ago. And I've been in business with my ex for the last 11 years and I'm sick of it. I need to sell them because I need to get out, right? I just stop the relationship somehow, get away from it. And that's what happens if you don't have proper plans, proper documents in place ahead of time. So within your operating agreement, your bylaws, or your partnership agreement, you can actually specify that if one of the partners goes through a divorce, that their interest will be bought out so that the equity can't transfer, but the value of that equity can transfer. You can set it up so that, if an ex becomes involved in the business and they end up getting equity, that they don't have any decision-making authority. So that even though they're a partner, technically they're a silent partner, right? So there are ways to structure these things to minimize the effect of a divorce. And a lot of times people say, well, that would never happen to me, right? But then when it does, you have a nightmare on your hands. You have issues that can't be easily overcome, that need to be addressed, and so on after the fact. And it's very difficult to address it after the fact. So these are things that proactively we want to look at. And then the final D is disillusion. So again, if you have a business partner, if you're in business with somebody else, you want to make sure that if you decide to go your separate ways, how does that happen? How is the business going to be wrapped up? How is it going to be terminated? Who gets to stay with the business? Maybe there's a shotgun clause in the documents that says, if somebody is dissatisfied with the relationship as a business partner, they can decide to leave the business. And if they decide to leave, then the other partner gets to buy them out under certain conditions. If they don't buy them out, then the partner that's exiting can buy out the one that would otherwise have triggered that clause, right? So there's different ways to structure these things so that it can be fair and it can make sense, and it can be handled more than anything outside of court, right? Because that's what most people want to avoid, is having to go through difficult court processes when these sort of business matters happen and when people want to go their separate ways. Just like a divorce, it can become very emotional and it can take a lot of toll on the process and the relationship if things aren't set up properly. But if you do have things set out properly in your operating agreement, your bylaws, your maybe a buy-sell agreement, then that can make the transition a lot more smooth and a lot easier to be able to continue operating the business. One of the biggest things that happens in business is that the goodwill that you create with your clients and your vendors and everything else, it's a delicate balance that can be easily affected and lost in the time of a transition or in the time of turmoil for a business. So if anything happens to the business owners, the rest of the business, the staff, the employees, the operations, everything is affected by it. And that's why it's so critical to have a proper estate plan or business succession plan if you're the owner, if you're the person everybody's relying on within the business. And of course, we'll be hitting on this, more in the future and on different aspects of business succession planning. But hopefully hearing about these 5 Ds is valuable. And at this point, as always, we want to open it up for if there's any questions that we can help answer and address with anybody who's listening.
Glenn, one question that I got was whether the type of business, like LLC or what have you, impact what you can do in terms of the structures that you can do on the estate planning side?
The approach of how it's done does vary and does change depending on the type of structure and the type of business that you have. What you can do doesn't really change that much. So, there's closely held businesses, maybe corporations or LLCs or partnerships that are really only owned by husband and wife and there's nobody else involved. Those are fairly easy to plan for because we can make sure that we can, put it into a personal estate plan so that somebody can step in and manage things in the absence of the business owners. If you have somebody else involved, partner or other shareholders or investors, then that's where it really becomes more complicated and we need to address it either in the corporate documents or in a standalone document specifically. We had one other question that came in, which was if you're in a community property state, assets are considered to be basically part of both spouses. And so does that also apply to businesses? And the answer is yes, that also applies to businesses. Unless you have documents in place that will limit the access or the rights of your ex-spouse or your current spouse, then it's considered an asset just like any other asset that could fall under community property guidelines, and it could automatically be something that your spouse would have an interest in or your ex-spouse would have an interest in the case of a divorce. So yeah, that is something that's important to address. All right. Well, if there's no other questions, we appreciate everybody for joining us today. We're going to continue having these conversations about estate planning. And, next week we're going to be hitting on asset protection planning in particular. And why is that important to have? How are some of the simple ways to address asset protection planning for yourself or for people that you know and that might need it? And again, we appreciate you tuning in, and we'll be sharing some of these insights in regards to estate planning in the weeks to come.
This has been Estate Planning Made Simple, a podcast by LSPN. Join us next week on Clubhouse and on all major podcasting platforms.